Welcome to
Ducky Channel.
Thank you for joining me on the brief of the Defendant Appellant Steve A. Avery. This is Part 6. Section 9. The Circuit Court erred as a matter of law in ruling that it was not authorized by statute to resolve claims of ineffective assistance of prior post-conviction counsel, and that Mr. Avery would have to pursue that claim with the Court of Appeals pursuant to State v. Knight. The Circuit Court held that a, quote, Circuit Court is not authorized by statute to resolve claims of ineffective assistance of appellate counsel, State v. Knight. In this matter, if the defendant wishes to pursue the claim regarding appellate counsel, the defense may file a Knight motion with the Court of Appeals. Part A. Standard of Review. When, as here, the Circuit Court's decision turned on a matter of law, the appropriate standard of review is de novo. Whether counsel was ineffective is a mixed question of fact and law. State ex rel flor versus state. Part B. Mr. Avery is not challenging ineffectiveness of prior appellate counsel. Contrary to the Circuit Court's interpretation, Mr. Avery is not challenging the effectiveness of appellate counsel. His claims focus exclusively on the deficient performance of prior post-conviction counsel in failing to raise the ineffectiveness of his trial defense counsel. Mr. Avery does not raise a single issue regarding his appellate brief or oral argument. The Wisconsin courts distinguish claims challenging the effectiveness of post-conviction counsel from those challenging the effectiveness of appellate counsel, holding that a claim of ineffective assistance of post-conviction counsel should be raised in the trial court. Describing procedure for challenging effectiveness of appellate counsel. Because Mr. Avery's ineffective assistance of counsel claims relate to his prior post-conviction counsel's failure to raise meritorious claim of ineffective assistance of trial rather than appellate counsel, he properly raised those issues in a 974.06 motion filed with the Circuit Court. The court in the Rothering stated, the distinction between appellate counsel and post-conviction counsel is a decisive point here. Quote, there are two principal manifestations of appellate representation, A, the brief, and B, oral argument. Because the issues Rothering alleges appellate counsel should have briefed were waived, neither manifestation of appellate representation was deficient. What Rothering really complains of is the failure of post-conviction counsel to bring a post-conviction motion before the trial court, raising the issue of ineffective trial counsel. The allegedly deficient conduct is not what occurred before this appellate court, but rather what should have occurred before the trial court by a motion filed by post-conviction counsel. We hold that a Knight petition is not a proper vehicle for seeking redress of the alleged deficiencies of post-conviction counsel. Rothering 205, Wisconsin. In Ballette, the defendant's post-conviction counsel raised two claims of ineffective assistance of trial counsel. After the trial court denied those claims, the defendant unsuccessfully appealed that denial. The defendant then filed a 974.06 motion for a new trial. Ultimately, the Wisconsin Supreme Court reviewed the manner in which the defendant had raised his claims of ineffectiveness of post-conviction counsel. After explaining the conduct of the defendant alleged to be ineffective was post-conviction counsel's failure to highlight the deficiency of trial counsel in a 974.02 motion before the trial court, the Wisconsin Supreme Court concluded that there could be no dispute that the defendant properly filed his motion in the Circuit Court. Part C. Mr. Avery's current claims are clearly stronger than prior post-conviction counsel's claims. Failure to hire experts. Prior post-conviction counsel ignored the ineffectiveness of trial defense counsel failing to retain experts. Clearly, prior post-conviction counsel recognized the need for experts on Mr. Avery's behalf because they asked the court for an extension to retain experts and stated as follows. Counsel would be remiss if they did not consult with scientific experts on matters beyond their own knowledge and expertise, just as counsel would fail to satisfy their ethical obligations if they did not pursue potential leads for post-conviction relief. Despite the fact that prior post-conviction counsel recognized the need for experts, they failed to retain a single expert to review the key pieces of forensic evidence that resulted in Mr. Avery's conviction. Prior post-conviction counsel failed to detect the illegal seizure of groin swabs taken from Mr. Avery. Prior post-conviction counsel failed to retain their own experts in blood spatter, ballistics, DNA, anthropology with kerf mark specialization, forensic pathology, police procedure, and audio enhancement, who would have been able to demonstrate that all the forensic evidence used to convict Mr. Avery was planted as summarized. Both trial defense counsel and prior post-conviction counsel were ineffective pursuant to Strickland in failing to hire the above-list experts. Their deficient performance falls below an objective standard of reasonableness. Mr. Avery was prejudiced by their deficient performance, finding ineffective assistance of counsel for the cumulative effect of their errors. The cumulative effect of trial defense and prior post-conviction counsel prejudiced Mr. Avery because both failed to review, quote, certain portions of discovery provided by the state, failed to, quote, master the discovery documents, failed to independently investigate certain lines of inquiry about Bobby and Mr. Hillegas, and failed to initiate an investigation of any additional evidence or information to impeach them. The trial court instructed that, in making a Strickland evaluation of prejudice, the, quote, totality of the representation standard is not the proper inquiry, but rather, quote, the effect of counsel's act or omissions on the reliability of the trial's outcome. The cumulative effect of all these deficiencies undermines confidence in the outcome of the trial and establishes Strickland prejudice. Even though prior counsel performed well on some aspects of the trial and post-conviction, it does not offset the cumulative effect of their deficiencies in failing to master the discovery, independently investigate third-party suspects, and obtain experts to undermine the very flawed theory used to convict Mr. Avery. Failure to raise ineffective claim re-impeachment of Bobby. Prior post-conviction counsel filed Mr. Avery's 974.02 motion immediately after trial and were ineffective under Strickland because they confined their ineffectiveness claim against Mr. Beauty and Mr. Strain to the narrow issue of juror removal. They overlooked the clearly stronger ineffectiveness claim of trial defense counsel's failure to impeach the state's primary witness, Bobby, and other witnesses, and to hire vitally important experts to dispute the state's experts. The court, in Reither v. Meisner, reversed the Wisconsin State Court decision to apply the wrong standard in Strickland. The Reither court noted that Strickland is the, quote, benchmark decision for claims of ineffectiveness and provides that the Sixth Amendment guarantees of assistance of counsel is violated if an attorney's actions are objectively unreasonable and prejudice the defendant. The Reither court stated, although the court identified Strickland as a controlling legal authority, it did not apply Strickland's framework. Rather, in assessing whether Reither was prejudiced by counsel's errors, the court required a showing of but-for causation. That is not the standard. Instead, a petitioner must demonstrate a reasonability probability defined as 1, quote, sufficient to undermine confidence in the outcome, that counsel's errors materially affected the outcome of the proceeding. In this battle of credibility, counsel's failure to make use of the witness's prior statement doomed Reither's prospects from the beginning. Had counsel cross-examined the witnesses adequately, he could have cast significant doubt on Danielle's and Bragg's testimony, which was ripe for impeaching. Prior post-conviction counsel failed to recognize the Strickland ineffectiveness argument that should have been raised about trial defense counsel's failure to recognize the significance of Brian's statement to the police and that Brian could have been called to impeach his brother Bobby on the pivotal issue in the case. Did Ms. Halbach leave the Avery property on October 31st, 2005? Finding deficient performance where trial counsel failed to investigate and call a significant witness. Prior post-conviction counsel failed to raise the clearly stronger Strickland argument regarding the failure of trial defense counsel to impeach Bobby. Steinkuhler v. Meschner, the effectiveness of prior post-conviction counsel is a sufficient reason to overcome the procedural bar relied upon by the circuit court in denying Mr. Avery relief on his current post-conviction motion. These failures combined and individually constitute textbook deficient performance. Counsel has a duty to make reasonable investigations or to make a reasonable decision that makes particular investigations unnecessary, finding deficient performance of trial counsel for failure to call a key witness. The defendant must show that counsel's failure resulted in prejudice. In order to demonstrate prejudice, Mr. Avery must show a, quote, reasonable probability that, but for counsel's unprofessional errors, the result of the proceeding would have been different. Quote, a reasonable probability is a probability sufficient to undermine confidence in the outcome. When a defendant alleges multiple deficiencies by trial counsel, quote, prejudice should be assessed based on the cumulative effect of the counsel's deficiencies. To be clear, prejudice is not an outcome determinative standard. The focus is on the reliability of the proceedings. The result of the proceedings can be rendered unreliable and hence the proceedings itself unfair, even if the errors of counsel cannot be shown by a preponderance of the evidence to have determined the outcome. Here, prior counsel's deficiency has rendered Mr. Avery's trial unreliable. The sole issues at trial were the forensic evidence linking Mr. Avery to the victim and the identity of the murderer. Trial defense counsel presented no real defense to the state's forensic evidence. Trial defense counsel called 7 witnesses and only 2 experts. Mr. Avery did not testify. The jury was left only with the state's unrebutted forensic evidence and the undisputed testimony of Bobby that Mrs. Halbach walked to Mr. Avery's trailer and was never seen again. All of the evidence incorporated in the Allen chart on page 99 through 103 applies to prior post-conviction counsel's ineffectiveness in conducting a significant investigation to impeach Bobby and others, and in failing to retain experts. The above listed claims are obviously stronger than the claims raised by prior post-conviction counsel. Rejecting a defendant's ineffective assistance claims where the defendant did not assert that the claim counsel failed to raise were obvious and very strong. Section 5. The Circuit Court abused its discretion in dismissing Mr. Avery's second motion, pursuant to Wisconsin Statute 974.06, without requiring the state to respond or conduct an evidentiary hearing. Part A. Standard of Review. The Wisconsin Supreme Court has ruled that a trial court may deny a motion for post-conviction relief under 974.06 statutes without a hearing if the motion fails to allege sufficient facts to raise a question of fact, or presents only conclusory allegations, or if the motion files and record conclusively shows that the defendant is entitled to no relief. Whether a defendant's post-conviction motion alleges sufficient facts to entitle the defendant to a hearing is a mixed standard of review. First, the appellate court determines whether the motion on its face alleges sufficient material facts that, if true, would entitle the defendants to relief. If the motion raises such facts, the circuit court must hold a hearing. This threshold inquiry is thus a question of law subject to de novo review. The circuit court's discretionary decisions are reviewed under the deferential erroneous exercise of discretion standard. As with any other civil pleading, in assessing the legal sufficiency of the motion, the court must assume the facts alleged therein to be true. Even if the court is disinclined to believe evidence offered by a movement, the court must hold a hearing before making credibility determinations. State v. Allen. Holding that when credibility is an issue, it is best resolved by live testimony. Only after a hearing is the court charged with determining the issues and making findings of fact and conclusions of law. In Roll, the defendant filed a motion for post-conviction relief. The circuit court denied the motion and the defendant appealed. The Court of Appeals reversed and the state petitioned for review. The Wisconsin Supreme Court held that, while the allegations in the petition were initially conclusory, the circuit court had permitted the defendant to supplement his allegations with an affidavit. Because the affidavit provided some support for the conclusory allegation, the Wisconsin Supreme Court held that the circuit court abused its discretion in dismissing the petition without an evidentiary hearing. In Zool v. State, the Wisconsin Supreme Court held that the circuit court abused its discretion because the motion set forth sufficient factual allegations, such that it should not have been summarily dismissed. Defendant's only support for his allegations was his own affidavit. The Circuit Court dismissed the motion, finding that the defendant's allegation was not supported by the previous trial court record. The Wisconsin Supreme Court explained, quote, "This is not the test. A silent record does not conclusively show that the defendant is entitled to no relief. The defendant's burden at the first stage of the act is to present an issue of fact that, if later proven at a hearing, would entitle him to relief." The court in Allen 2004 determined that a motion contains sufficient material facts for an evidentiary hearing if it includes, quote, "the name of the witness who, the reason the witness is important, why, how, and facts that can be proven what, where, when, that clearly satisfies the Bentley standard and would entitle a defendant to a hearing." As the chart illustrates, Mr. Avery has met all of the Allen requirements. Who? Stuart James, blood spatter experts. What? Ineffective, assistance of counsel, failure to hire experts. Mr. Avery's blood was selectively dripped in the RAV4, was therefore planted. Where? Mr. Avery's blood in the RAV4. When? Mr. Avery's blood discovered in RAV4 on November 5th, 2005. Why/how? Supra at P 68 through 72. Footnote 9, 10, and 11. In the course of her investigation, current post-conviction counsel has obtained affidavits from 14 experts. Current post-conviction counsel has obtained 22 affidavits from 17 lay witnesses. Current post-conviction counsel has obtained 3 affidavits from Mr. Avery's trial attorneys. Lucien Haig, ballistic expert. Ms. Halbach was not shot through the head because number FL has no bone particles. Mr. Avery's garage floor, March 1st, 2006, Supra at page 72-73. Dr. Christopher Palnick, Ph.D., trace expert, using a 2016 scanning electron microscope, determined that number FL was not shot through Mrs. Halbach's head. Hood latch, swab did not swab hood latch. Mr. Avery's garage floor, RAV4, March 1st, 2006, April 3rd, 2006, infra at page 104 through 106, 108 through 109. Dr. Carl Reich, Ph.D., DNA expert. Mr. Avery's DNA planted on RAV4 hood latch and subkey. Mrs. Halbach's RAV4, Mr. Avery's trailer, April 3rd, 2006, November 8th, 2005. Supra page 73 through 74, 77 through 78. Dr. Stephen Symes, Ph.D., forensic anthropologist. Microscopic examination should have been done to confirm suspected human pelvic bones were human. Mantrock gravel pit, November 2005. Supra page 78 through 79. Dr. John D. Hahn, Ph.D., forensic fire expert. Mrs. Halbach's body not burned in Mr. Avery's burn pit. Mr. Avery's burn pit, November 8, 2005. Impra at page 109. Dean Strain admits ineffectiveness in failure to hire experts. Bloodstain patterns, RAV4. Number FL Avery Garage, pre-trial and during trial, Supra page 68 through 73. Ineffective assistance of counsel, failure to investigate and impeach Bobby. Brian Dassey, Blaine Dassey. Brian impeaches Bobby regarding Miss Halbach leaving Avery property. Blaine lied at trial about fire in Mr. Avery's burn barrel. Dassey residence, November 4th, 2005. Supra page 84 through 86. Infra at page 121. Greg McCrary, police practice and investigation expert. Hillegas and Bobby as third-party suspects. N.A. October 31st, 2005, November 3rd, 2005, and April 23rd, 2006. Supra page 86. Conrad Baez, investigator for trial counsel, admits failure to investigate Bobby. Dassey residence, November 6, 2005. Brian's interview. Supra page 84 through 85. Ross Colby, audio enhancement expert. Audio enhancement impeaches Sergeant Colburn. MCSD dispatch call, November 3rd or 4th, 2005. Supra page 79. Dr. Larry Blum, MD, forensic pathologist. Bobby lied about origin of his back scratches. Aurora Medical Center, November 9th, 2005. Supra page 86 through 87. Brady violations. Ramlow, Redant, Dassey Yonda, CD. Kevin Ramlow, eyewitness. Brady violation RAV4 being planted. Turnabout at the East Twin River Bridge on Highway 147, July 15, 2017. Supra on page 41 through 43. Josh Redant, witness, impeachment, re RAV4 planted, Avery Salvage Yard, November 5th, 2005, Supra, page 45 through 46. Denise Heidel, witness, establishes direct connection of Ryan Hilligus to crime scene. Mrs. Halbach's location unknown at time of phone call, October 31st, 2005, Supra, page 48 through 49. Gary Hunt, senior forensic examiner, Brady Unique, Felly word, searches withheld from trial defense counsel. Dassey residence, April 17, 2018, Supra, page 56 through 59. Dr. Ann Burgess, Ph.D., link between violent pornography and crime, Dassey residence, April 17, 2018, Supra, page 60. Jerome Buting, Brady violation re, Dassey computer, Dassey residence, pretrial, Supra, page 5253. Dean Strain, Brady violation re, Dassey computer, Dassey residence, pretrial, Supra at page 53 through 54. The Circuit Court erred in weighing the scientific evidence rather than granting an evidentiary hearing. The Circuit Court concluded that, quote, defendants' experts could not reach definitive conclusions regarding items of evidence without further testing. The Circuit Court specifically attempted to weigh the evidence about the DNA experiments performed by Mr. Avery's DNA expert on a RAV4 hood latch. The Circuit Court misinterpreted the statistical significance of Dr. Reich's findings and erroneously concluded that the DNA on the hood latch was deposited by sweat from Mr. Avery's hand when Dr. Reich had stated there is no DNA in sweat. The Circuit Court misinterpreted Dr. Reich's affidavit to state that there, quote, is no forensic test available that can conclusively determine whether DNA was left by sweat. Of course, there is no test available because there is no DNA in sweat. In order to assist the court, Dr. Reich prepared another affidavit in which he explained the misperceptions of the Circuit Court. Dr. Reich stated that he had sufficient independent tests to support his conclusions. The Circuit Court also tried to weigh the evidence about the subkey as a result of the experiments performed on it. The Circuit Court ignored the experiment performed by Dr. Reich of Mr. Avery holding an exemplar key and deposited 10 times less DNA than the amount detected by the WSCL. The Circuit Court chose to focus only on the allegation that the key was a subkey. Finally, and most significantly, the Circuit Court completely misread Dr. Palnick's affidavit about the lack of bone particles and presence of wood on number FL. The Circuit Court claimed that Dr. Palnick's report, quote, is not that clear-cut. The Circuit Court claimed that Dr. Palnick did not, quote, discover all particles present on the bullet's surface. The Circuit Court failed to comprehend Dr. Palnick's statement that only, quote, if indications of bone were detected by these methods, further analytic approaches could be applied to more specific confirm its presence. Dr. Palnick responded to this erroneous interpretation by stating that the court was incorrect that the entire bullet surface had not been examined for the presence of bone. The Circuit Court also erroneously concluded that Dr. Palnick's report, quote, indicates that the test performed cannot determine what the red substance on the bullet is, and that further testing would be needed. Dr. Palnick clearly stated in his affidavit. Regardless of its identity, the texture of the bullet in the area where the droplets are observed strongly suggests that the droplet was deposited after the bullet was fired and came to rest. The material could be identified as subjected to further analysis. Emphasis added. Clearly, if the droplets were deposited after the bullet came to rest, it is immaterial what the substance is. Dr. Palnick disputes the Circuit Court's conclusion and states, this court also misconstrued my statements in regarding my observation of 2 red droplets on the surface of item FL. I pro-offered the opinion that the color, texture, and shape of the red droplet deposit suggest that the material may be paint and that it could be tested to identify it. There has never been an issue in the underlying case that the red droplets were blood because at trial, the forensic analysis Sherry Culhane testified that she had not done a presumptive test for blood, nor had she observed any stains on the bullet fragment. She also testified that she had washed the bullet fragment in a solution. The following observations all suggested that the material on the bullet is composed of paint. A. The property of the droplets that were observed. B. The fact that bone was not detected on the bullet. C. The fact that the bullet had been previously extracted specifically for DNA. D. The fact that no indications of blood were previously noted during prior examinations, E, the presence of additional bullet holes in the garage where this bullet was found, and F, evidence that red paint was used to paint the garage as well as objects in the garage which would suggest a source for the bullet. Dr. Pelnick also states, though this material could be identified by sampling and analyzing the drops, analyses that were expressly prohibited and outside the scope of my analysis of the bullet. The identity of the material was not pursued further due to the above listed facts of the case, which together with the lack of any prior indication of blood on the bullet, suggests that these droplets on the bullet are composed of paint. The Circuit Court ignored Dr. Pelnick's findings that numerously fibers were found on the bullet's surface, some embedded in wax and other embedded on the bullet's surface. There is no question that the state's theory as to the cause of death was gunshots to Miss Halbach's skull. The absence of bone particles on number FL completely refutes that it passed into Miss Halbach's skull, as the state's expert, Dr. Jenston, opined. The Circuit Court completely misread Dr. Pelnick's affidavit as requiring further testing. No such testing is necessary because Dr. Pelnick has established that the state's contention that number FL caused Miss Halbach's death is false. The Circuit Court also erroneously concluded that State v. Allen, 2004, was inapplicable because the records are speculative and lack conclusions. The Circuit Court failed to acknowledge its errors in interpreting the expert reports and determined that the reports, contrary to the experts' own opinions, were interim and therefore speculative. Section 6. The Circuit Court erred as a matter of law in applying the wrong standard to the newly discovered evidence. In its October 3, 2017 ruling, the Circuit Court stated, the defendant attached numerous reports to his latest motion, arguing that the forensic tests concluded in the reports were not available at the time of the defendant's trial in 2005. However, the defendant's arguments ignore an important question. Were the tests available at the time of the defendant's previous motion pursuant to Wisconsin Statute 974.06 or any of the other appeals or motions filed after trial? The Circuit Court ruling that in order for evidence to be, quote, new, the testing methods used to obtain it must not have been available at the time of Mr. Avery's prior appeals and or post-conviction motions is manifestly erroneous. That is not the standard. When moving for a new trial based on allegation of newly discovered evidence, a defendant must prove, number 1, the evidence was discovered after conviction. Number 2, the defendant was not negligent in seeking the evidence. Number 3, the evidence is material to an issue in the case. And 4, the evidence is not merely cumulative. If the defendant is able to prove all 4 of these criteria, then it must be determined whether a reasonable probability exists that had the jury heard the newly discovered evidence, it would have had a reasonable doubt as to the defendant's guilt. State v. Love. If the defendant was not negligent in failing to ferret out the evidence on which he relies, then a prior motion brought pursuant to Wisconsin Statute 974.06 does not procedurally bar the claim. State v. Edmonds. Defendant's prior post-conviction motion did not bar a successive post-conviction motion based on newly discovered medical evidence calling into question state's evidence related to shaken baby syndrome. In State v. Brian Avery, 2013, the defendant filed a motion under Wisconsin Statute 974.06 over 12 years after his conviction and argued that during that time, new technology had allowed him to develop new evidence of his innocence. The Circuit Court denied the motion, but the Court of Appeals reversed the post-conviction order and remanded the matter for evidentiary hearing, concluding that the defendant had made a prima facie claim of newly discovered evidence. The Appellate Court applied the test discussed above from Edmonds and determined that the defendant met all 4 prongs of the test. As to the first prong, the defendant was not required to establish when the new technology was available. The defendant satisfied his burden by simply showing that the technology was not available at the time of his trial. Similarly, Mr. Avery, in the case at bar, has satisfied his burden by setting forth in his motion that the new technology was not available at the time of trial. The new technology is as follows. Number 1. Dr. Palnick examined number FL using state-of-the-art technology not available at the time of Mr. Avery's trial in 2007. Dr. Palnick's examination of number FL and his findings have produced new evidence that is totally inconsistent with the state's theory that Ms. Halbach was shot in the head while laying on Mr. Avery's garage floor. Number 2. Dr. Palnick, using a 2016 microscope to analyze the hood latch swab and conduct a series of experiments, has offered the opinion that the swab was not used to swab the RAV4 hood latch. Number 3. John DeHaan, Ph.D. Dr. DeHaan, a forensic fire expert, has conducted more experiments on human cadavers than any other fire forensic expert in the world since 2012. Dr. DeHaan's experiments refute the state's theory that Ms. Halbach was burned in Mr. Avery's burn pit. Number 4. Dr. Reich was able, through the use of new source DNA, RSID testing, to eliminate the following rich sources of DNA from the hood latch swab: blood, semen, and saliva. The circuit court never addressed the undisputed fact that Mr. Avery had demonstrated through Dr. Reich's experiments and source testing that the DNA on the hood latch was planted. There is no innocent explanation for the large quantity of DNA on the hood latch if blood, saliva, and semen are ruled out. The only plausible explanation is a large quantity of DNA came from illegally seized groin swabs, which Dr. Reich said would provide a comparable quantity of DNA as that found on the hood latch. Ultimately, the question is whether there is a reasonable probability that the jury, after hearing the new evidence, would have reasonable doubt of the motivant's guilt. The question has been answered about the state's theory that number FL caused Ms. Halbach's death. It did not. Therefore, Ms. Halbach's DNA was planted on number FL. Also, Ms. Halbach's body was not burned in Mr. Avery's burn pit. This question is not answered by simply weighing the evidence, because a jury can find reasonable doubt even if the state's evidence is stronger. This same principle is applicable to the prejudice prong of Strickland and the determination of whether the state committed a Brady violation. Holding the application of a preponderance of the evidence standard to analyzing prejudice under Strickland is improper. Holding that the reasonable probability standard for materiality of suppressed evidence is less rigorous than a preponderance of evidence standard.
'Cause the days are gonna whisper and the months are gonna talk until the years yell out the truth. Time will tell, time will tell on you. When a train whistles far away and when